Our jury panel.
And Judge Lancito is now back on the bench.
My
We'll listen.
apologies to you for those interruptions, and my apologies to Ms. Clark for having interrupted her train of thought there. A couple of things happened that I needed to deal with immediately, and I apologize to you for the disruption in the thought process. We will go through at this point until 5 o'clock, and then we'll take our mid-afternoon recess. And however, I realize that since we're having extended hours, one or two of you may have a need for a comfort break. So if you do, just raise your hand, get the bailiff's attention, and we'll take a quick 5 or 10 minute break if you need to during the longer hours. Ms. Clark?
Thank you, Adam. Good afternoon. Okay. So now we've talked about conduct, we've talked about opportunity and timing. Let's talk about the physical evidence. I'm not going to do it in the detail you've already heard it, heaven forbid. But although you've already seen, with the opportunity evidence, with the conduct evidence, we already have evidence to show you that the defendant did commit these murders without even really getting into the physical evidence. And once you see the vast array of physical evidence, you can see that there's virtually an ocean of evidence to prove that this defendant committed these murders. What all of it does, all of this evidence, is it links the defendant to the victims and the crime scene at Bundy. Now, the defense has gone to great lengths to try and to show that they could discredit this evidence, and the lengths that they have included have been some of the most bizarre and far-fetched notions I think I have ever heard. Now, the defense has gone to great lengths to try and to show that they could discredit this evidence, and the lengths that they have included have been some of the most bizarre and far-fetched notions I think I have ever heard. They've hinted that blood was planted. They've tried to create the impression that multiple other blood stains were contaminated, and that somehow all the contamination only occurred where it would consistently prove the defendant was guilty. So now the little amplicons, the little DNA, they're co-conspirators too, because they know they've got to rush to only the places where you can attribute the blood to the murderer. When you think about that, just think about that one point logically, okay? Obviously, it's common sense. If contamination is going on, you're going to see it going on all over the place. As a matter of fact, if what they're saying is true with this aerosol effect, flying DNA all over the place, then Mr. Simpson's blood type ought to be showing up in other cases. Somewhere out or down in another department in a rape case, Mr. Simpson's type should be showing up because it's everywhere. Or even just to confine it to this case. Talk about that. How come, if the argument is that his blood is flying all over the place, DNA is flying all over the place, why didn't we find his blood type showing up where it obviously shouldn't be? What I mean is this. They took samples from the pool of blood by Nicole's body. They took samples of blood that was near Ron Goldman's body. Obviously, the blood came from them because they were lying there. And then, of course, you have the blood drops leading away from the crime scene. That had to be left by the killer. There's no question about that. That was left by the killer because they're next to the bloody shoe prints. So you know. Why is it that the sample of blood they took from her pool of blood didn't come up with the defendant's blood type? If the defendant's blood type DNA is flying all over the place, it's flying all over the place. Then it ought to be all over the place. Why isn't it in the pool of blood sample that was taken from Nicole Brown? Why isn't it in the pool of the blood sample that was taken from near Ron Goldman's body? Logic, common sense. It ought to be there. The DNA, the amplicons, those little things, they don't know where to go. They're not guided. Contamination is a random thing. Happens willy-nilly. And what you have here is they're trying to get you to believe that only the killer's blood was contaminated, and it was consistently contaminated with only the defendant's blood type. Does this make any sense to you? What you ought to have, if you have contamination, if you've got a problem here, is that some of the blood drops come back to the defendant, and some don't. They come back to the real killer. That's what you ought to get, because it can't be this consistent. If you had one blood drop in this case, ladies and gentlemen, you might be concerned with all of these possibilities they've raised. But you have so many. You have so many. You've got 5 blood drops leading away from the bodies of the victims out to the driveway, and you've got the blood on the rear gate. And that's the other part of their scenario that makes no sense. No sense. You have all these police officers that were there on June the 13th. Officer Risky, saying his partner, young rookie named Officer Terrazas, shined his light on the rear gate to show him the blood on the rear gate. You have Officer Risky seeing the blood on the rear gate. You have Officer Rossi seeing the blood on the rear gate. You have Detective Phillips seeing the blood on the rear gate. All of it early on. Dennis Fung, whom you can see, is not the model of efficiency, forgot to collect it. And from this we get a theory that seem to imply that the blood was planted. Why do they say that? Now, first of all, I want to hear Mr. Cochran actually stand up in front of you and tell you he believes the blood was planted. I want to hear that. Because that is incredible. That is absolutely incredible. When you think about that, think, what evidence have you been given to show you how that blood was planted, to show you when that blood was planted, to show you who planted that blood? Now, the reason that they have to come up with this story about contamination and planting, and I want to hear if they really do that, say that to you, is because they can't get around the result. You recall Dr. Gerdes testified for the defense, and he said that the DNA testing that allowed for RFLP, the most powerful of the techniques of DNA, was successful on the rear gate because that blood had higher molecular weight DNA. From the fact that you have higher molecular weight DNA on blood collected later, July 3rd, they want you to infer that somehow it was planted. But they're inconsistent because if you remember, now if you plant the blood, aren't you going to plant it close to the time you collect it? What are you going to do? Plant it and hope somebody finds it later? You plant it when you expect someone to find it, right? When they have the EDTA going on, you have all these cross-examination questions about EDTA breaking down due to sunlight exposure. There's no proof that that happens, by the way, as you could tell. And they did no tests to prove that that happens, by the way. Would be nice. If they want to prove that, do a little testing. You've got the expert right there. Why didn't he do any tests, by the way? But he didn't do any. Okay? So they're asking him about EDTA breaking down in the sunlight, trying to infer that it was there for 3 weeks, that the blood was there. If it's there for 3 weeks, it wasn't planted, folks. It was there on the night of the murder. This is what I mean by inconsistent, illogical. This makes no sense. If you're going to say that the blood was planted, then you're going to say that it was planted at or near the time of collection, in which case the EDTA would not break down, in which case the EDTA should be intact, in which case you should see the kind of high, smooth arc that the graphs showed you from the reference tubes, instead of the jagged noise that you actually saw. And they brought in Dr. Readers to try and tell you that that jagged noise looks just like that high arc, which is ridiculous, which is insulting to your intelligence. But the reason that they have to say this, defying logic, defying common sense, is because, ladies and gentlemen, his blood on the rear gate, with that match that makes him 1 in 57 billion people that could have left that blood. I mean, there's 5 billion people on the planet? That means you'd have to go through 57 billion people to find the DNA profile that matches Mr. Simpson's. There's only 5 billion people on the planet. Ladies and gentlemen, that's an identification. Okay? That proves it's his blood. Nobody else is on the planet. No one. Now, they know that. Now, the blood on the socks. Nicole's blood on the socks. Again, RFLP match, very powerful. Showed from Cellmark, that was a 5-probe match, I believe, found to be 1 in 6.8 billion people. Again, more than there are people on the planet, identification. An 11-probe match by DOJ showed that it was 1 in 7.7 billion people. Again, her blood, and only hers on this planet, could be on that sock. Now, how do you get around that? It wasn't wrong, and they couldn't find an expert who would say it was contaminated because there's too much DNA. That is the blood. That type is the type. It is her blood. How do you get around that? And if you know that that's true, if you know it's her blood on his socks that they find on the morning of June the 13th, that alone, with the rear gate stain, convicts him. You can't believe otherwise. You have so much proof now. How do they get around that? They have to find a theory to get around that. And what do? This is what they come up with. So if it's low in volume DNA, it's contaminated. If it's high volume DNA, it's planted, and it's also very convenient and ridiculous. Now, their experts had access to all of the evidence in this case. Their experts could have come in and shown you how the evidence got contaminated. Got contaminated. Not possibly. Remember I talked to you about mere possibility? No. Did get contaminated. And they could have come in here and told you and pointed out the evidence that showed why only the blood drops left by the murderer got contaminated, and shown you why they consistently and only got contaminated in a way that showed the defendant's DNA type. Not that they possibly could have. Yes, possibly we're all sitting on Mars right now, you know, and I'm from Venus and I'm talking, anything's possible. Let's talk about what did happen. Let's talk about what we've got. They could have shown you proof that the Bundy blood drops were contaminated, not the mere possibility. No, I'm talking about evidence that gives you a reason to conclude that that happened, and that they never could do. And they could have done it if it were true, but they didn't. And not one expert they brought in on the DNA did even one test on the blood evidence, the evidence that we have that proves to you that the defendant committed these murders. Not one. With all those experts you saw. And the reason for that, ladies and gentlemen, is that it isn't true. The blood on the Bundy trail comes back to the defendant because it's his blood. The blood on the rear gate comes back to the defendant because it's blood he left there on the night of the murders. So they took you through all this tortured and twisted road. One moment saying that the police are all a bunch of bumbling idiots. The next moment they're clever conspirators. And now ask yourself, did they ever prove who planted? When? How? And it's a fact that the defense doesn't have to prove anything. That's a fact. But once they do decide to put on a case, once they decide to try and prove something, their witnesses are subject to the same scrutiny as the people's witnesses are. Your jury instruction, as I've told you, makes no distinction. It's up to them to do the best job that they can to make their point. And I think a good example of how they failed to do that miserably in this case is the EDTA, that preservative that you find in the purple top tube. They've got to make you believe that blood was planted. It's the cornerstone of their defense. It really is, because as I've pointed out, if you know that's his blood left on the rear gate, if you know that's her blood on his socks, what are you left to conclude? Now, what do they do to show you, to prove to you the cornerstone of their defense? What do? They take our tests, and they have some other expert who neither did the test himself nor could come in and try and interpret those graphs for you. Not only that, but he does it inconsistently. He writes a report, if you recall, he wrote a report in which he said he found one parent ion and one daughter ion, not the full daughter spectrum that would permit identification of EDTA, but the same finding of one parent ion, one daughter ion, that Mr. Martz said he found in his own blood, in his own unpreserved blood, which tends to prove, which does prove, that the blood on the rear gate, the blood on the socks, are just like Agent Martz's unpreserved blood, natural blood, not from a preservative tube. So what did they do with that? Here's what happened. Dr. Reeders wrote that report, and he said the blood on the sock, the blood on the gate, one parent ion, one daughter ion. Wrote that report, I believe, on July 17th. A few days after he wrote the report, he found out that Agent Martz had just done the test on his own blood and come up with the same result he got on the sock and the gate. Very, very low noise readings, and only 2 of the 3 ions he should have found, which leads you to understand that it was unpreserved blood. Well, now he's got to do something about that. He has to answer that contradiction, because now what we've got is he can't address this. We have proven conclusively it was not EDTA blood. He's got to do something to make his testimony weave its way around. And don't forget, in case you had, we even did prove that their contamination theory was untrue. If you remember, we had a lot of testimony in what we call substrate controls. Now, all the substrate controls are, it's really, I think you'll remember, it's very simple. You go and you collect a blood stain from here, and then in order to make sure that the blood type you're going to pick up there isn't the result of something underneath that was already there before the blood came down, you take a little swatch right next to it to show that the ground underneath didn't have any DNA. And we did that. That was done at Bundy, next to every blood stain, systematically done. Now, how do they help you? When you go to test the swatches, the blood stain swatches and the controls are tested the same way. And if you have contamination, the controls should come up showing DNA. And the controls on the Bundy walk did not. And there you go. Oh, I wanted to go over an instruction with you. This is a long instruction that has particular relevance to this case. It's called, this is the instruction about circumstantial and direct evidence. There's a lot of words in this instruction, I must say. Let me first say something to you about direct and circumstantial evidence. This instruction explains them both. I don't know how well. You know, I'm not a big fan of these, the way they're written. I think they could be a lot clearer, frankly. But they talk about direct and circumstantial evidence. This one is just circumstantial evidence. You have another instruction that distinguishes between the two. You're told in these instructions that direct and circumstantial evidence are of equal weight. Neither one is better than the other. Now, an example of direct evidence would be an eyewitness, someone who would say, I saw him, I saw that. We have an eyewitness in Alan Park, okay? His testimony seeing the man we know to be the defendant walking into the house at Rockingham. Alan Park testified to his observations. That's direct evidence, okay? Circumstantial evidence is evidence that leads you to infer. Okay? For example, in this case, the blood. The blood at Bundy dripped by the killer next to the bloody shoe prints. It's not direct. Somebody didn't see the murder being committed, didn't see the murderer leaving the scene of the crime, but you have the blood of the murderer left behind. It's kind of like, well, and you have the blood on the rear gate that actually identifies Mr. Simpson. That's kind of like a fingerprint. Okay? That's circumstantial evidence, as opposed to seeing it. Now, in terms of quality, there's no difference. The law has no favorites. But when you think about it logically, circumstantial evidence has a lot of benefits that direct evidence doesn't. What is that? It gives you a lot of quality assurance. It gives you independent corroborating bases on which to believe that the defendant is guilty. Instead of relying on one person's observation, one person who might be mistaken, who might be tired, who might not have observed very well. You know what happens because you saw it happen in this case. What happens with an eyewitness? They start out saying, for example, a robbery. Okay? I was standing on the street corner and I saw the defendant go over to the woman and grab her purse. Okay? Purse snatch. Okay? Cross-examination. How far away were you from that woman? Where were you standing? Were they standing in shadow? Do you wear glasses? How much of the defendant's face did you see? Half? 3/4? Only a quarter? What kind of hair did he have? What kind of shirt did he wear? What kind of pants did he wear? What color eyes did he have? Did he have a goatee? Did he have a mustache? Did he have a beard? And so on and so forth. And the witness starts to get torn down. And if that's all you've got is that person's observation, it can make you a little unsteady about whether or not you really have enough proof to give you that certainty that you need. Now, contrast that with the following. You have the defendant committing a purse snatch. And what you have is someone who hears the woman scream, sees the back of a man running, and then a few minutes later, the defendant is caught 3 blocks away holding her purse. Assume for a moment that she cannot really identify her attacker. You got him with her purse just a few minutes later. A lot of things can be said about how it got to him, but that's circumstantial evidence. But even that circumstantial evidence is not nearly as good. It doesn't come close to what we have in this case. In this case, you have circumstantial evidence of the blood, you have hair and fiber, and you have some of the conduct evidence and the opportunity evidence. You have a wealth of evidence in this case, all pointing to one person, the defendant. Now, this instruction, usually when I see lawyers argue this, they take out one paragraph, they only talk about that one. I want to talk about the whole instruction here. Okay, begins in the very first paragraph with the fact, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only 1, consistent with the theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. You'll see the word reasonable, rational throughout these jury instructions, because that's what it's all about. Reason, common sense, logical, rational. All right, now I'm going to jump around between this, and I'm going to come back and forth to this instruction because there's a lot here. But in the third paragraph, this is what I told you about a little bit earlier. If you have 2 reasonable interpretations, remember I gave you the example of the Bronco that could have been on Ashford or could have been gone completely at the time that Charles Cale was walking his dog. You had 2 reasonable interpretations from that evidence when he said he couldn't see the Bronco on Rockingham. At the point in time that he testified, based on his testimony, you had 2 reasonable conclusions to draw. Either that it was not there at all, or that it was on Ashford and he didn't see it. When you have 2 reasonable interpretations, one of which points to guilt, and the other to innocence, you adopt the interpretation that points to the innocence and reject that interpretation which points to his guilt. That is when they are equally susceptible of 2 reasonable interpretations. If, on the other hand, one interpretation of the evidence appears to you to be reasonable and the other to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Reasonable, rational. The defense will argue to you many things, inferences that could be drawn, just like the possibilities I talked to you about. Ask yourself, are they reasonable? Because if they are not, if those inferences are not reasonable, then you are to reject them and accept the reasonable. And that's why I keep referring to common sense, rational, logical. All right, I'd like to start with hair and fiber. If you remember, Mr. Diedrich testified about the microscopic comparisons of hair and fiber in this case. And when he did so, well, first let me point something out. His testimony was uncontradicted by any other expert. His testimony is not disputed. His conclusions are not disputed. And you know that the hair and fiber evidence was examined by at least 2 other experts for the defense. Now, when Mr. Diedrich testified, he told you what his conclusions were based solely on what he could see through the microscope. That's all he can tell you about. He did not take into account the results of the DNA testing. He didn't take into account the testimony of Cato or of Alan Park. None of that. He looks through a microscope. So all he can tell you is that the defendant's hair shares the same microscopic characteristics as, for example, the hair in the knit cap found in Bundy, or the hair found on Ron Goldman's shirt. He can only say it's consistent, shares the same microscopic characteristics. But when you take into account all of the evidence, including the DNA, including the testimony of Cato and Park, including the defendant's opportunity to commit the murders, including his post-homicidal conduct. You know it's his hair. You know it's that fiber. So now we are going to put it all together. So when I talk to you now about that's the defendant's hair in the cap, I'm talking about not just Doug Diedrich's testimony. I'm talking about his testimony along with everything else, all the reasonable inferences that you can draw, all the logical conclusions that you come to, knowing all that we know in this case. Now, I'm not going to talk about every conclusion that Mr. Diedrich testified to. Some of them were only testified to give you more information, more background, more knowledge about what you expect to find in this testimony. So let's start. What I'd like to do is start with the bodies at Bundy and move away from them as the defendant moved away from them after the murders, and analyze all of the evidence that was left behind from that perspective. And just so you know, I will show you a couple of photographs from the crime scene, but I'm not going to put up any coroner's pictures. I've seen enough of that for a while. So when I describe the wounds from the coroner and that sort of thing, I'm just going to describe them. You're not going to see pictures from me. You can see them back in the jury room if you like. All right, let's start with the knit cap. Can we get the Bundy board? The knit cap. You can barely see it under the plant here. This is the position in which it was found. Now you can see how the defendant could miss it in the dark. It's underneath that plant. I'm pointing to it right here, that blue, patch of blue here. On that knit cap, you recall that it's the defendant's hairs. Now let me refer specifically to Mr. Diedrich's testimony in this regard, because what he told us is this. He said there were the hairs that he said were consistent with the defendant's. He found 9 inside the cap. And it's clear, extrapolating from his testimony, it's clear that they were 9, I think, naturally shed hairs is what he said. Not fragments, but naturally shed hairs. That he wore the cap from that. Now, what's interesting also is that he talked about fragments that were found inside the cap, hairs of black origin that were not consistent with Mr. Simpson's. And so I asked him, what about those hairs? Well, he said they were treated, chemically treated. How long were they in the cap? Can't tell. They could have been there for years. Because you can, life experience, if you ever had anything knit like that, kind of a loose weave, and you'll have it in evidence, you can check it out. It's going to get hairs in it, and those hairs could stay there for a very long time if it's not washed, if it's not laundered. So that's why I asked the defendant's hairdresser. What about the defendant's former wife, Marguerite? Did she treat her hair? What about Arnell? Did she treat her hair? These are other possible people that could have worn the cap and whose hair the fragments, old fragments, could be from. But the 9 naturally shed hairs inside the cap that were consistent with the defendant's were different in quality than those because they were not fragments and therefore unlikely to be old. All right, and taking into account everything that we know, those were his hairs in the cap. He wore the cap. He also found on that cap fiber, and he said it was consistent with the carpet from the defendant's Bronco. And he talked to you about the unusual nature of the trilobal cross-section of that fiber, and he showed you photographs of it that were taken from the scanning electron microscope. You'll have that back in the jury room if you want to see it. It's very interesting stuff. But what we know, from all we know, that was a fiber from the defendant's Bronco on that cap. Now that's very important because that actually, with that cap, we have tied the defendant and his car to the crime scene at Bundy. And now you see, to summarize, on the knit cap we have the defendant's hair and the Bronco fiber from the carpet in his Bronco. And another piece of the puzzle. Now let's go to Ron's shirt. Now Now, on Mr. Goldman's shirt, we have the defendant's hair, and we have the blue-black cotton fiber. Now, of course, the defendant's hair is of obvious significance. Mr. Diedrich was asked whether or not that hair appeared to be the hair that he said was consistent with the defendant's, whether it appeared soiled. He said no. That was very important, and that was very important for this reason. If we had simply found hairs of the defendant in the soil of that area,